The Supreme Court upholds the temporary restraining order and writ of preliminary injunction issued by the Court of Appeals on dismissed Makati Mayor Junjun Binay's preventive suspension. Bianca Dava will tell us why live. Bianca?
Gerry, the Supreme Court has affirmed the power of the Court of Appeals to review and resolve petitions questioning the orders issued by the Office of the Ombudsman. The recent ruling is in connection with Ombudsman Conchita Carpio Morales' first suspension order against Makati Mayor Junjun Binay Jr. over the alleged overpriced Makati City Hall Building 2. On March 11, the Ombudsman issued a 6-month preventive suspension against Binay and other city officials, which was followed by the oath-taking of acting Mayor Romulo Kid Peña. After several hours, the CA issued a temporary restraining order and a writ of preliminary injunction stopping the implementation of the suspension order. The anti-graft court then took the case to the High Court. During their en banc session on Tuesday, the Supreme Court rejected the position of Morales that only the Supreme Court has jurisdiction to handle the case, as stated under Section 14 of Republic Act No. 6770 or the Ombudsman Act of 1989.
The second paragraph of Section 14 of Republic Act No. 6770 is declared as unconstitutional, while the policy against provisional injunctive writs by courts other than the Supreme Court to enjoin an investigation conducted by the Office of the Ombudsman under the first paragraph of the said provision is declared ineffective.
Aside from this, Supreme Court Public Information Chief Attorney Thio said the High Court has abandoned the condonation doctrine. The condonation doctrine is commonly invoked by elected public officials to escape previous administrative liabilities because of re-election.
Cited lack of basis in the Constitution and the law for abandoning the condonation doctrine, which was first enunciated in Pascual versus Provincial Board of Nueva Ecija, a 1959 case. The court noted that the condonation doctrine is not based on statute, and considering the change in the constitutional framework for public accountability across constitutions, it is also not based on the 1987 Constitution.
However, TEC clarified that the abandonment of the doctrine is prospective in effect, meaning it applied to the CA's issuance of the WPI in Binay's case, but the doctrine can no longer be invoked in future cases. Gerry, moreover, the Supreme Court said, considering that the Ombudsman had already found Mayor Binay administratively liable over the alleged anomaly and imposed on him the penalty of dismissal on October 9, the Court of Appeals ought to dismiss the mayor's petition for being moot and academic. Gerry?
Thank you, Bianca Dava, reporting live from the Supreme Court.